steps to address climate change. I will be followed by Mrs. Sheribder, who will address the vertical dimension, setting out how existing patterns of marginalization and inequality must inform states' duties to protect those most affected by climate change. Mr. President, members of the Court, let me start with a broad observation. This hearing takes place in the shadow of COP29 summit. As you have already heard this morning, there are already sharp debates about whether the outcome of that meeting was sufficient to address the looming threats of climate change. Albania shares the concern expressed in the joint submissions by the Vanuatu and Melanesian Spearhead Group, and I do not repeat those here. Speaking in Baku, Albania's Prime Minister, Mr. Edi Rama, expressed his and Albania's frustration with the current state of debate about climate change, commenting that, I quote, "Life goes on with its old habits and our speeches, full of good words about fighting climate change, changing nothing," end of quote. In his scripted statement, he highlighted the importance of global ambition and collective action and shared responsibility. The Court's voice, its opinion, addressed to the General Assembly and also the wider world, will be critically important and delivered at a critically important time. We urge the Court to be bold, direct, and clear in its statement of what the law requires to meaningfully address the threats we face. It is Albania's view that the law as it stands today requires states and others to take meaningful action to address climate change. We are not asked to make new law. This is neither your task nor your competence. You are, though, asked to advise both on the obligations of states under international law and on illegal consequences under those obligations for states whose acts and omissions have, over time, caused significant harm. Your opinion should, therefore, in Albania's view, address the responsibility of states, including with regard to obligations to address and regulate conduct, both action and inaction, that causes or would cause significant harm to the climate system or part of the environment. You are asked, in declaring the law as it is, to bring a clarity to the law that will both allow and require states to take the action required of them and require accountability for failure to do so. Mr. President, members of the Court, I now turn to my more substantive submissions. Climate change is a global crisis. This unprecedented level of participation by states in these proceedings underscores an undeniable truth. No state will be spared from the far-reaching impacts of climate change. This appreciation of itself demands a bold, direct, and clear statement of what the law requires. But this appreciation is only part of the picture. Its effects are and will be felt unevenly, both by states and by peoples. As the World Bank has noted, it is developing and middle-income nations that are, I quote, likely to bear the greatest burden of climate change in terms of loss of life and relative effect on investment and the economy. Take Albania. We are a middle-income country at the heart of Europe. We have consistently produced some of the lowest levels of CO2 and anthropogenic greenhouse gas emissions in Europe. Yet, as the World Bank has recognized, we are one of the countries most severely affected by climate change. The Albanian coastline, a key part of our national life and driver of our tourism and economic growth, faces severe threats from rising sea levels, coastal erosion, and extreme weather events. Changes in rainfall patterns and increasing temperatures threaten the agriculture sector, a vital pillar of our economy. Albania's celebrated reliance on hydropower, approximately 90% of our electricity generation, is undermined by water scarcity caused by drought and erratic precipitation. Our progress, hard-won over decades, hangs in the balance. Climate change threatens our economic stability, erodes our social resilience, and obstructs our path towards sustainable development. Our neighbors in the Western Balkans face similar challenges. Our region is one of the areas in Europe most heavily affected by the impact of climate change. This trend is projected to worsen, with temperature rise expected to increase to 4 degrees and potentially beyond 5 degrees by the end of this century. Despite Albania's proactive mitigation and adaptation efforts, the scale of the measures required far exceeds our available financial resources. The World Bank estimated that we require $6 billion of investment for adaptation measures alone, more than 1/4 of our GDP. The Western Balkans collectively needs $37 billion for adaptation. This financial burden should not be borne alone by our economies. By our people, we are in need of assistance. Mr. President, we are neither shirking our responsibility nor advancing a case for development aid, pulling on the heartstrings of developed states, pleading for handouts. In our view, while all states must mitigate emissions, to enable this, the law imposes differential responsibilities on states. Greater action is required of those whose actions have contributed and will continue to contribute most acutely to climate change, and of those who can most afford to take meaningful actions to address the threats. The Special Rapporteur on Human Rights to Clean, Healthy and Sustainable Development has observed, I quote, "The main contributors to the problem have reaped immense economic benefits and thus have the greatest responsibility to solve the problem." This observation lays bare the injustice at the heart of the climate crisis and underscores the need for your advisory opinion to affirm expressly two existing and complementary sets of legal obligations. First, that developed, industrialized states, those who possess greater resources and, historically, bear disproportionate responsibility for global greenhouse gas emissions, are obligated to take material steps in significantly reducing emissions. Second, that these states are obligated to contribute financial resources to facilitate technology transfer and to build capacity to enable developing and middle-income countries to mitigate the impacts of climate change and adapt to its adverse effects. These obligations are not novel or controversial. They are at the heart of a golden thread that runs through the corpus of international law you are asked to examine. For instance, the Kyoto Protocol includes multiple provisions expressly requiring state parties to cooperate to take all practicable steps to promote, facilitate and finance the transfer of or access to technologies and know-how pertinent to climate change, in particular to developing countries. Similarly, amongst the key obligations of the Paris Agreement are the following. First, that developed state parties shall provide financial resources to assist developing state parties with respect to both mitigation and adaptation. Second, that parties shall strengthen cooperative action on technology development and transfer. Third, that support, including financial support, shall be provided to developing state parties, including for strengthening cooperative action on technology development and transfer at different stages of the technology cycle. An affirmation of this differentiation of obligations is also found in UNCLOS, which, as ITLOS clarified in its recent advisory opinion, requires state parties to provide, I quote, scientific, technical, educational, and other assistance to developing states that are particularly vulnerable to the adverse effects of climate change, end of quote. As the Tribunal recognized, doing so is a means of addressing the inequitable situation of climate change. These differential obligations also find expression in the customary obligation of states to prevent transboundary harm, where developed and industrialized states have a more stringent due diligence obligation. Moreover, as recognized by numerous states, these differences in obligations are an expression of the general principles of cooperation and equity. Mr. President, members of the Court, Albania urges the Court to have this central legal truth at the center of your advisory opinion, that developed, industrialized states bear the primary responsibility to take meaningful action as required by law to address the climate change crisis to which they have and are continuing to contribute disproportionately, and that this includes real and tangible support for developing and middle-income countries that bear the brunt of the worst of its devastating impacts. This advisory opinion will be closely considered and carefully applied in many fora affecting developing and middle-income states' climate actions. In the international investment space, guidance is needed on how states' climate-related obligations should be taken into account. While Albania welcomes and supports responsible investments, climate action must not be compromised by inappropriate arbitrary decisions that have not taken proper heed of legal imperatives relating to climate change. Albania urges the Court to affirm that commercial interests should be protected proportionately, ensuring a careful and equitable balance between states' climate obligations and investors' protected interests, an imperative not yet fully realized. Mr. President, Madam Vice President, distinguished members of the Court, this concludes my submissions. May I ask Mr. President to invite Mrs. Blair to the podium. I thank you for your attention.